Talked to a client one day recently, and I told him about the timeline for a caveat case. And he goes, "That's interesting." He had found me on the internet, and he said, "You should talk about that." So thank you for that tip, client. Let's talk about what is the process in a caveat case. First of all, if you've seen other videos or read anything, a caveat is a Superior Court litigation in North Carolina. It's challenging the last will and testament of a decedent. There's plenty of other articles I've written and talked about undue influence that's done to the person that draft or executed the will, the decedent, the testator, or lack of capacity, or the formalities for doing the will were improper. Those are challenges. That's a different topic. This is sort of a schedule. So for you as my potential client, I'm going to hit some of the high points. I'm not going to give you all the secret sauce, but I'm going to tell you this is what you're looking at when you file a caveat. First of all, the caveat is the equivalent of a complaint. You're saying, beware, we're challenging the will, don't rely on that will as good. And when you do file the complaint, or at least when I filed the caveat, you got to serve via summons, via Rule 4, all the parties that have an interest either in the will or intestate or by a prior will, and you got to name them all. You got to do that. But when I do it, I go ahead and hit them with everything. Liz Pendens, the real property. That means I put a notice that don't buy the real property on this will. It's going to be challenged. You might not get good title. I send discovery. And again, you got to serve it. Well, nothing really happens once you've served them until you do what's called an alignment hearing. That's about, I like to go ahead and push mine on because that's when the case really gets rolling. And the parties line up. They choose caveator, challengers, propounders, defenders. So there's usually someone on the other side that says, no, this will is good. And they're the propounders and they're the defenders. You move on down, you have that hearing, the judge sets up and says, A and B, your caveators or your propounders. Now, I actually had the situation one time. I had a client, they're like, we don't really want to line up on either side. And we mulled that over because they came out well either way. And we finally determined if you don't align, then you don't get to go to the table. You don't get to participate in the trial. And if there's a settlement, you don't participate in the settlement. So we aligned. We basically flipped the coin to decide whether we're going to be propounder or caveator. Strange case. Worked out well for them. So after the alignment hearing, there's a discovery period. I've been practicing law for 25 years. I forget that a lot of people aren't familiar with discovery periods. So discovery is depositions, I'll come back to that, interrogatories, requests for admissions, requests for production. That's what discovery is. So interrogatories, they're written requests. Please list all witnesses to decedent and whether he was competent or not. Please provide the estate planning attorney's file on this matter. Please list all medical providers for the last 3, 5, 7 years for the decedent. That's an interrogatory. Request for production of documents, which is another one, is please give us all medical records for the last 3 to 5 years. Please give us all tax returns. Please provide all bank records, that sort of thing. Requests for admissions are just asking certain questions, admit or deny these. And now a deposition. A deposition is when you put a witness under oath and a court reporter transcribes every word that's asked by the attorney and every word that's answered by the witness. It's under oath. It's fact-finding. All this is fact-finding to build for the case. That's discovery. I've listed them out here. Oh, and sometimes you got to subpoena things, such as phone records, such as the attorney's estate planning file, different matters like that. We had one case, I bet we sent out 25 subpoenas. including the life insurance companies and such. All right, somewhere in this process, you start figuring out, typically these are medical cases. What did the doctor say? What did the records say? You find out what the doctor who treated, if they remember decedent, what they thought of decedent's capacity and physical and mental weaknesses. But you may ultimately need to designate an expert. Sometimes it's a neurologist, sometimes it's a geriatric physician, all different types. I had one time, because of liver failure, we had a gastroenterologist, and he talked about how with the liver failing, the ammonia levels built up and that affects capacity. Timeline, initially filing the caveat, time to answer a line, 30 to 60 days. Getting discovery started, there's usually motions to compel. No one likes to provide discovery. Even though we have open discovery in North Carolina, I still deal with some frustrating attorneys that don't provide things unless you take them to court and force them. So the discovery, you're looking at 6 to 9 months after you file before that finishes up. And somewhere approximately in the 9-month period after the caveat's been filed, you'll have mediation. What's mediation? Mediation is when you have an independent attorney go between the parties, go room to room, and try to get this settled. And they'll go into each room and they'll say, tell me about your case. And you'll tell them about the best parts of your case. What do you want? And you'll tell them what you're demanding. And they'll go to the other room and say, this is what they want, this is why they think their case is great. And the other side, usually the propounder, will respond second, says, well, that's wrong. Let me tell you, this is why we think we have a good case. And they'll argue their points. And then the guy, the mediator, will come back into the other room and say, what about these weaknesses in your case? But you'll keep negotiating, you'll keep making offers. You never go right to where you want to end up. You dance a little bit. I know it's frustrating, but you got to dance. So that's 9 months. If you can't settle, and in North Carolina, we've been doing mediations for 30 years, and they actually have cut down on the number of trials we do. When I first came out in the 90s, we'd stack them in. One time I was second trial of a week, jury trial of a week. These days, it's not as often that we have jury trials. Unfortunately, I miss it. But mediation has created a situation where now 90% or more of all cases settle. Now, somewhere in here, there will be summary judgment motions if you have such a good case. And it's rare in a will caveat, or rarer, I've had a couple, to win at summary judgment. That means the evidence is so overwhelming and there's no issue of fact to counter that. But if you don't, then you get ready, and I always say to my clients that our chief judge in this county, and this is how I base it, I'm in Forsyth, but I go statewide. I got a case in Dare County. I've gone up in the mountains. But here in Forsyth, we'll usually be on the trial calendar 1 year after we file. And they expect us to present our case 1 year after we file. Thank you, Chief Judge. I don't like cases to drag along. So if it goes all the way, you're typically looking at 1 year. Again, most cases will resolve somewhere in that 6 to 9 month period, but you've got to suss things out. You've got to get some records. That's the timeline for a will caveat case.